Hello dear learners. The topic for today's discussion is institutional mechanism for the prevention of corruption, which is very much important in public administration because certain mechanism should be devised to hold the public officials accountable. Students, we shall be discussing this topic under following headings. First of all, introduction, causes of corruption, remedies to fight corruption, various institutional mechanisms, Central Vigilance Commission, Central Bureau of Investigation, the Comptroller and Auditor General of India, Lokpal and Lokayukt Act, and the conclusion. Now, first of all, introduction. Lord Acton's insightful remark, power corrupts and absolute power corrupts absolutely, appears to have universal validity. Corruption has always been a primary concern, if not a problem, of all systems of governance at all times. Corruption means deliberate and intentional exploitation of one's position, status or resources directly or indirectly for personal aggrandizement, whether it be in terms of material gain or enhancement of power, prestige or influence beyond what is legitimate or sanctioned by commonly accepted norms to the detriment or the interest of the other person or the community as a whole. Santhanam Committee gives an interesting twist to the definition of corruption in public systems. Any action or failure to take action in the performance of duty by a government servant for some advantage is corruption. Administrative malpractices may take many forms. Numerous are the forms of corruption and abuse of authority. Lord Acton's remark that power corrupts and absolute power corrupts absolutely appears to have a universal applicability in all the systems of governance. Corruption is the root cause of problem of maladministration, which like a termite is slowly eroding the foundation of a nation and hinders the administration from completing its task. Corruption has been defined as the use of public power for private profit in a way what constitutes the breach of law. The scope of corrupt activity is expanded by including within its ambit action as well as non-action, though the motivation in both the cases seems to be similar. Corruption involves misuse of official position or authority, deviation from rules and norms, non-action when some action is required to be taken, personal gains for selfish motive and harm to public good. Now, causes of corruption. Following can be enumerated as the causes of corruption: lack of proper education and training of civil servants, inadequate and inefficient supervision, political patronage of officials, lack of transparency of public dealings, cumbersome administrative procedure, non-disclosure of assets and income, license permit quota raj, social environment, political corruption, poor public opinion, unwillingness of the people to complain against corrupt practices. Now students, various causes can be enumerated behind the corruption. Few of them are like civil servants lack proper skills and training to perform their administrative jobs, which leads them to involve in corrupt practices. Lack of proper supervision by the seniors of their administrative officials also is a cause of corruption. Political refuge or asylum given to the public officials by the leaders in the power is a main cause of the corruption. Next is lack of proper transparency, openness in the public dealings. Files in government offices are marked as top confidential, secret, and this leads to many scams which take place due to the openness or lack of transparency in the government office. Then administrative procedures are very cumbersome and dilatory in the underdeveloped countries or developing countries like India, and we see that it is the bureaucracy which is a cause of corruption. Files keep on moving from one table to another. Next is there is no compulsion or any convention or law which asks a public official to disclose his income or assets. This also leads to corruption. Then the licensing or control regulation, which has got the nickname of the license permit quota raj. it also is a cause of corruption. It provides enough space and opportunity for corrupt practices. Then administrative culture. Administrative culture in the third world countries and especially in the underdeveloped or developing countries like India is one of the cause of the corruption. Public officials or bureaucrats have their own attachments to various caste, communities or other sorts, which leads them to involve in corrupt practices and allows them to do favoritism. Then political corruption, political leaders themselves are involved in corrupt practices. If top is corrupt, then how will you be able to clean up the bottom? Next is public opinion. Poor public opinion, unawareness among the masses, among the common man is the root cause of the corruption. And lastly, we can say that unwillingness of the public, unwillingness of the common man to report against the corrupt practices leads to the more and more corrupt practices continuing in the country. Now students, remedies to fight corruption. The Committee on Prevention of Corruption, Santhanam Committee, made a range of recommendations to fight the menace of corruption. It recommended the constitution of the Central Vigilance Commission and Administrative Vigilance Divisions in all departments and major organizations of the government. The committee suggested rules to be framed for governing the conduct of civil servants. In all, the Santhanam Committee made 137 recommendations. Out of these, 106 were accepted by the Government of India. Consequently, the Indian Penal Code was amended to expand its scope. The Special Police Establishment was strengthened. The Central Bureau of Investigation, Central Vigilance Commission and State Vigilance Commission were created. Article 311 of the Indian Constitution for conducting disciplinary proceedings against government servants was also amended. So students, we see that just after independence, corruption has started permeating the whole body politic in country, and there was a continuing demand for initiating effective measures to contain corruption in public service. The Committee on Prevention of Corruption was set up in 1962 under the chairmanship of the eminent parliamentarian K. Santhanam with 4 other MPs and 2 senior officers. The Santhanam Committee, as it came to be called as, was asked to give suggestions for the prevention of corruption in all the government departments. It recommended for the setting up of a Central Vigilance Commission and Central Bureau of Investigation to curb corruption in all the government departments. After the Santhanam Committee, the first and the second Administrative Reforms Commission also looked into the problem of politico-administrative corruption. The ARC recommended the establishment of 2 special institutions, the Lokpal to deal with complaints against the administrative acts of ministers and secretaries to the government at the centre, and the Lokayukt to deal with such complaints in the state. So students, after the report of the Santhanam Committee, the government set up the first administrative commission under the chairmanship of Morarji Desai and later on taken over by K. Hanumanthayya, and the second Administrative Reforms Commission under the chairmanship of Virappa Moily, and these 2 Administrative Reforms Commission suggested for the setting up of the institutions of Lokpal at the centre and the Lokayukt at the state to file the complaints against the administrative acts of the ministers and the secretaries to the government. Now students, coming over to the various institutional mechanisms designed to curb the corruption in the country. First of all, Central Vigilance Commission. The commission was set up on 2nd February 1964 in order to advise the central government on all matters pertaining to the protection of integrity in administration. CVC is conceived to be the apex vigilance institution free of control from any executive authority, monitoring all vigilance activity under the central government and advising various authorities in the central government organization. Later, CVC was made a multi-member commission with statutory status. CVC bill was passed by both the houses of the parliament in 2003. The government authorized the CVC to receive written complaints for disclosure on any allegation of corruption or misuse of office and recommended appropriate action. So, students, first of all, Central Vigilance Commission, as recommended by the Santhanam Committee in its report in 1964, government established CVC for the curbing the corruption activities at the central level. CVC later on was made a multi-member organization, and the government authorized the CVC to receive all the written complaints against corruption and for the disclosure of any allegation of corrupt practices or misuse of any public office and recommended the appropriate action under the CVC. Powers and functions: to chair the committee, exercise superintendence over the functions of the Delhi Special Police Establishment DSPE under the Prevention of Corruption Act 1988, to undertake an inquiry or investigation to be made into any transaction in which a public servant working in any organization is suspected or alleged to have acted for an improper purpose or in a corrupt manner, to tender independent and impartial advice to the disciplinary and other authorities in disciplinary cases, to exercise a general check and supervision over vigilance and anti-corruption work in ministries of the Government of India or departments and other organizations to which executive power of the Union extends, to chair the committee for selection of director, CBI, director enforcement and other officers of SP level and above in DSPE. So, students, powers and functions of the Central Vigilance Commission extends to the exercising superintendence over the functions of the Delhi Special Police Establishment, which comes under the Prevention of Corruption Act 1988. Then it is also responsible to hold an inquiry or investigation to be made into any transaction in which a public servant is involved or is alleged to have involved in a corrupt or wrong practices. Then CVC is also responsible for exercising a general check or supervision over the vigilance and anti-corruption activities in the various ministries of the Government of India and various departments and other organizations which comes under the executive powers of the government. Then lastly, CVC is also consulted in the selection of the Director of Central Bureau of Investigation, Director of the Enforcement and other officers of the SP rank in various departments. Working of the Central Vigilance Commission. The Commission receives complaint against central government employees allegedly involved in corrupt practices and misconduct either directly from the complainants or through the various departments concerned. Some of these complaints are found to be anonymous or pseudonyms. Every complaint is examined from the point of view of CVC's jurisdiction. Complaints are forwarded to the administrative authorities concerned, including the Central Bureau of Investigation or CVOs, for detailed investigation and reporting. After investigations are completed, the Commission is consulted on further action. So, students, under the working of the CVC, CVC is entitled to receive all the complaints against the central government officials or employees who are involved in the alleged practices of corruption or misconduct. These complaints can be filed directly to the CVC, and in mostly cases these complaints are received from the from anonymous writers or writers with a fake name, that is pseudonyms. Every complaint received by the CVC is examined by the CVC under its jurisdictions, and then these complaints are forwarded to the administrative authorities concerned for the further action. Next is Central Bureau of Investigation. CBI was established on 1st April 1963 as an attached office of the Ministry of Home Affairs. At present, it is attached to the Ministry of Personnel, Public Grievances and Pensions. It is responsible for preparing and implementing comprehensive program of vigilance and anti-corruption. Over the years, it has evolved into a premier investigating agency of Government of India to investigate complex and important cases. Central Bureau of Investigation has its offices all over the country. Students, Central Bureau of Investigation is an elite force playing the major role in national security for the preservation of values in public life and for ensuring the health of the national economy. Central Bureau of Investigation collects information on all the cases of corruption with the help of governmental as well as non-governmental agencies. It prepares a list of persons and organizations who are engaged in malpractices, corrupt practices or corrupt activities, and checks and searches on receipt of definite information about the prevalence of malpractices, and then subsequently it takes the necessary required action against the particular public official. Composition of Central Bureau of Investigation. Central Bureau of Investigation has several divisions and specialized units, a brief reference to which is made below. Anti-Corruption Division, Special Crimes Division, Economic Offence Division, Policy Division, Administrative Division, Directorate of Prosecution, Central Forensic Science Laboratory, Training Division, Coordination Division, Systems Division, Technical Advisory Units. So, students, Central Bureau of Investigation has various divisions and specialized units which work accordingly. First of all, there is Anti-Corruption Division. It is responsible for collecting intelligence with regard to the corruption, maintaining liaisons with various departments through its vigilance officers. It inquires into the complaints about bribery and corruption. Next is Special Crimes Division, which handles cases of internal security, espionage and sabotage, narcotics, antiquities, murders, forgeries, dowry deaths or some other suspicious deaths. Then Economic Offence Division investigates the financial crimes, money laundering cases, bank frauds, graft in public sector undertakings and banks. Then Public Division, it deals with all the matters relating to the procedure or policy, organization, correspondence and implementation. Then Administrative Division, which is responsible for looking after the matters related to the personnel, establishment and accounts. There is Directorate of Prosecution, which is established for conducting prosecution in the CBI cases. Then Central Forensic Science Laboratory, it provides expert opinions on various aspects of forensic sciences concerning crime investigation. Then Training Division of Central Bureau of Investigation comprises of the Academy, which is located at Ghaziabad, and it is a modern police training center and imparts the specialized knowledge and skills that goes to make a modern crime investigator. Next is Coordination Division, which works in coordination with the International Criminal Police Organization, that is Interpol. Then there is Systems Division, which is responsible for looking after the information and communication needs of the Bureau. Lastly, Technical Division, which provides expert guidance in banking, taxation, engineering, foreign exchange matters during the enquiries and investigations. CBI investigations have a major impact on the political and economic life of the nation. CBI handles the following broad categories of criminal cases: cases of corruption and fraud committed by public servants of all central government departments, central public sector undertakings and financial institutions. Economic crimes including bank frauds, financial frauds, import, export and foreign exchange violations, large scale smuggling of other contraband items, special crimes such as cases of terrorism, bomb blast, sensational homicides, kidnapping for ransom and crimes committed by the mafia underworld. So, students, CBI handles various categories of cases. It handles the cases of corruption, fraud committed by the public officials of central government departments or other central public undertakings and other financial institutions. Then it handles the economic crimes committed by various public officials, financial frauds, import, export, foreign exchange violations, and Central Bureau of Investigation also handles the special cases involved like terrorism, cases of bomb blast, some sensational murder cases, some sensational or kidnapping cases or some crimes committed by the mafia or the underworld don. Now, next is the Comptroller and the Auditor General of India. A systematic audit of the accounts of government ministries, departments, enterprise and agencies can be instrumental in pointing out irregularities in financial dealings, maladministration and corruption. For this, the Comptroller and Auditor General of India, assisted by the Accountant Generals in various states, has considerable opportunity to go into those cases where corrupt practices are suspected to have influenced government action. Students, the Constitution of India, which was enforced in 1950, it provided for the establishment of a Comptroller and Auditor General for India. It is an independent body mentioned in the Constitution. The chief function of this Comptroller and Auditor General of India is to audit the accounts of the central and the state governments. This Comptroller and Auditor General has been instrumental in causing various corrective actions on the part of central as well as state governments, and it is this Comptroller and Auditor General in its report have highlighted the various scams and scandals like Bofors scandal, 2G spectrum, Commonwealth Games scam, etc. Appointment and term of office. The provisions regarding the appointment and conditions of service of CAG are laid down in Article 148 of the Indian Constitution. CAG is appointed by the President by warrant under his hand and seal for a period of 6 years up to the age of 65 years. He can be removed from office in the like manner and on the like grounds as in the case of a judge of Supreme Court. Any person appointed as the CAG takes an oath before the President of India. Now, organizational structure of CAG. CAG discharges his duties and functions through Indian Audit and Accounts Department. He is the head of Indian Audit and Accounts Department and derives his constitutional standing as the auditor of the union and state governments from articles 149 to 150 of the Indian Constitution. He is assisted by 5 Deputy Comptroller and Auditor Generals of India. One of Deputy CAGs is also the Chairman of the Audit Board. Below the Deputy CAG are 4 additional Deputy Comptrollers and Auditors General of India. The hierarchy in CAG's office comprises Assistant Comptroller and Auditor General of India, Director General, Principal Directors and Deputy Directors. One director acts as secretary to CAG. At the regional level in various states, there are number of accountants generals who acts as an agent of CAG in performing their functional and supervisory responsibilities at the state level. Students, the CAG is the head of the Indian Audit and Accounts Department, and it derives its constitutional standing from the articles of the Indian Constitution from 149 to 150, which provides for the establishment of the CAG. He is assisted by various Deputy Comptroller Auditor Generals in the discharging of his functions. Now, duties and powers of CAG. To prescribe with approval of the President the form in which the accounts of the Union and of the states are to be kept, to perform such duties and exercise such powers in relation to accounts of the union and state and of any other bodies or authority as may be prescribed by any law made by Parliament. To report to the President or to the governors of the state on the accounts of the union or states. Students, the statutory duties of the CAG includes auditing the receipts and expenditure of the union and the state governments, transactions relating to the contingency fund and public accounts, trading, manufacturing, profit and loss accounts and balance sheets, and other subsidiary accounts kept in government departments, accounts of stores and stock kept in government organizations and companies and corporations, and accounts of bodies and authorities receiving loans and grants from government for specific purposes. CAG's independence. Constitution of India ensures CAG's independence by following provisions. CAG is appointed by the President of India by warrant under his hand and seal and holds office for a period of 6 years from the date he assumes office or until he attains the age of 65 years, whichever is earlier. He cannot be removed from his office except on the grounds of proved misbehavior. His salary and service conditions cannot be varied to his advantage after he is appointed. After retirement or resignation, he is not eligible for any further office under the Government of India or any state. Students, CAG, that is Comptroller and Auditor General of India, cannot function in an independent manner unless and until he enjoys certain constitutional protection and privileges. Therefore, Constitution of India provides for independence of CAG through following provisions. First of all, we see that CAG is appointed by the President of India. Then, to ensure his independence from the executive government of the day, it has been provided that CAG cannot be removed from his office except on the grounds of proved misbehavior or incapacity by the President after an address by each houses of the Parliament supported by majority of 2/3 members present and voting is issued. Next, the administrative offences of the CAG, that is his salaries, etc., are charged upon the consolidated fund of India, which is not subject to the vote of Parliament. And to ensure the independence of the CAG, it has been provided that his terms of conditions, service and his salaries cannot be turned to his disadvantage during his appointment or after his appointment to the office. Next, it has been provided in the Constitution that after the resignation or after the retirement of the CAG, he is not entitled to hold any further office under the Government of India or under any of the state governments. Students, we see that it is one of the very positive feature of the Indian government system that CAG's independence has rarely been questioned and his reports and comments have always been given due respect by the various governments. Now, next is Lokpal and Lokayukt Act. Lokpal and Lokayukt Act 2013 provided for the establishment of Lokpal at the center and Lokayukt for the states. These institutions are statutory bodies without any constitutional status. They perform the functions of an ombudsman and inquire into allegations of corruption against certain public functionaries and for related matters. Lokpal is a multi-member body that consists of one chairperson and maximum of 8 members. The Lokpal can inquire into offences under the Prevention of Corruption Act 1988. Students, we have seen that India against corruption, a major movement led by Anna Hazare, it put pressure on the United Progressive Alliance government at the center, which resulted in the passing of the Lokpal and Lokayukt bill in 2013 in both the houses of the Parliament, and this bill received the assent of the President on 1st January 2014 and it came into effect on 16th January 2014. In this context, independent institution of the Lokpal and Lokayukt has been seen as a landmark move in the history of Indian polity, which offered a solution to the never-ending menace of corruption. Now, summing up, the foregoing analysis of the various institutions set up for the prevention of corruption in India makes it clear that administrative corruption is rooted in the administrative as well as non-administrative sources. The need is to catalog all the possible factors impinging on the problem of corruption and then tackle those which fall within the zone of feasibility. What is perhaps a most significant priority in the battle against corruption is to initiate and sustain systematic as well as administrative reforms which can directly or indirectly contribute to the mitigation of corruption. Notably, education for administration also requires a fresh orientation. Training to civil servants should also focus on its ethical component. So far, the methodology devised for ethical training has not advanced to a satisfactory level. No amount of legal or administrative action can be successful in curbing corruption in an effective manner unless a social climate evolves where corrupt persons, however successful they may be, suffer social opprobrium. So, students, after analyzing the various institutional mechanisms for the prevention of corruptions like Central Vigilance Commission, Central Bureau of Investigation, the Comptroller and Auditor General of India, and the establishment of the Lokpal and Lokayukt, we come to the conclusion that still much has to be done to remove the termite of corruption from the administration. The concept of corruption has narrowed down to the graft, bribery and illegitimate gratification in the country. To contain and combat corruption, it is primary concern of the government and the people. How people will have to be made aware of the responsibilities, and public awareness should be accompanied with a sense of social responsibility in the ruling elite. Procrastination must give way to promptness in tackling corruption. So, that is all about the institutional mechanism for the prevention of corruption. I hope this lecture will prove beneficial to all the students. Thank you.